Deputy Chairman of Council. Like the Chairman, the Deputy Chairman, he is elected by the Council itself from among its members. And the Deputy Chairman, he vacates his office in 3 conditions. If he ceases to be a member of the Assembly, if he resigns by writing his resignation letter to the Chairman, and if he is removed by a resolution that is passed by a majority of all the then members of the Council. And a prior notice should be given within 14 days in advance. The Deputy Chairman, he performs the duties of the Chairman's office when it is vacant, and he also acts as the Chairman when the Chairman is absent from the sitting of the Council. In both the powers, he has all the powers of the Chairman. A Chairman nominates from amongst the member a panel of Vice Chairman, and any one of them can preside over the Council in the absence of Chairman or Deputy Chairman, and he has the same powers as the Chairman while he is presiding, and he holds his office until a new panel of Vice Chairman is nominated. Sessions of State Legislature. Summoning. The Governor, from time to time, he summons each House of State Legislature to meet, and the maximum gap between the 2 sessions of the State Legislature, it cannot be more than 6 months. That is, the State Legislature should meet at least twice in a year, and a session of the State Legislature, it consists of many sittings. Adjournment. An adjournment suspends the work in a sitting for a specified time, which may be hours, days or week. Adjournment sine die means terminating a sitting of State Legislature for an indefinite period, and the power of adjournment as well as adjournment sine die, it lies with the presiding officer of the House. Prorogation. The presiding officer declares the House adjourned sine die when the business of the session is completed, and after this, within the next few days, the Governor issues a notification for prorogation of the session. Dissolution. The Legislative Council, being a permanent house, is not a subject to dissolution. Only the Legislative Assembly is subject to dissolution. A dissolution ends the very life of the existing house, and a new house is constituted after the general elections are held. Quorum. Quorum is a minimum number of members required to be present in the House before it can transact any business. So, it is 10 members or 1/10 of the total number of members of the House, including the presiding officer, whichever is greater. If there is no quorum during a meeting of the House, and it is the duty of the presiding officer either to adjourn the House or to suspend the meeting until there is a quorum. Voting in the House. All matters at any sitting of either House, they are decided by majority of votes of the members present and voting, excluding the presiding officers. But only few matters which are specifically mentioned in the Constitution, like removal of the Speaker of the Assembly or removal of the Chairman of the Council, and on a requirement of special majority, not ordinary majority. And also remember that the presiding officers, they does not vote in the first instance, but they exercise a casting vote in case of an equality of votes. Language in the State Legislature. The Constitution has declared the official languages of the state, or Hindi or English, to be the languages for transacting business in the State Legislature. The presiding officers can permit a member to address the House in his mother tongue, and the State Legislature is authorized to decide whether to continue or discontinue English as a floor language after the completion of 15 years from the commencement of the Constitution, that is from 1965. So in case of Himachal Pradesh, Manipur, Meghalaya and Tripura, this time limit is 25 years, and that of Arunachal Pradesh, Goa and Mizoram, it is 40 years. Rights of Ministers and Advocate General. In addition to the members of a house, every minister and advocate general of the state, they have the right to speak and take part in the proceedings of either house or any of its committees of which he is a member. And legislative procedure in state legislature. Ordinary bills. Bills in the originating house. An ordinary bill, it can originate either in legislative assembly or legislative council in case of bicameral legislature, and such a bill, it can be introduced either by minister or by any other member. The bill passes through 3 stages in the originating house, that is first reading, second reading and the third reading. And after the bill is passed by the originating house, it is transmitted to the second house for consideration and passage. A bill is deemed to have been passed in the state legislature only when both the houses have agreed to it, either with or without amendments. In case of unicameral legislature, a bill passed by the legislative assembly, it is directly sent to the governor for his assent. Bill in the second house. In the second house also, the bill passes through all the 3 stages, that is first reading, second reading and the third reading. And when a bill is passed by the legislative assembly and transmitted to the legislative council, and the legislative council has 4 alternative options. They are: the legislative council, it may pass the bill as it is sent by the assembly without amendments, or it may pass the bill with amendments and return to the assembly for reconsideration, or it can also reject the bill, or it may not take any action and it can keep the bill pending. And if the legislative council passes the bill without amendments or the assembly accepts the amendments which is suggested by the council, the bill is deemed to have been passed by both the houses and it is sent to the governor for his assent. And suppose, think, legislative assembly, it rejects the amendment which is suggested by the council, or the council, it rejects the bill, or the council does not take any action for 3 months, and then the assembly, it may pass the bill again and transmit the same to the legislative council. And if the council rejects the bill again or passes the bill with amendments not acceptable to the assembly, or it does not pass the bill within 1 month, then the bill is deemed to have been passed by both the houses in the form in which it was passed by the assembly for the second time. That is, for the second time where the legislative assembly passes the bill, and that becomes final. And we can say that the ultimate power of passing an ordinary bill, it is present in the legislative assembly. Assent of the governor. Every bill, after it is passed by the assembly in case of unicameral legislature, or when it is passed by both the houses in case of bicameral legislature, it is to be presented to the governor for his assent. And the governor has 4 alternatives. He has 4 options. He can give his assent to the bill, he can withhold his assent to the bill, or he can return the bill for reconsideration, or he can reserve the bill for the consideration of the president. And if the governor gives his assent to the bill, that bill becomes an act. And if the governor withholds his assent to the bill ends and it does not become an act. If the governor returns the bill for reconsideration, and if the bill is passed by the house or both the houses again, with or without amendments, and it is presented to the governor for his assent, and when it is passed for the second time to the governor for the assent, the governor must give his assent to the bill at any cost. And therefore, we said that the governor enjoys only a suspensive veto, and this position is same at the central level also. Assent of the president. When a bill is reserved by a governor for the consideration of the president may either give his assent to the bill or withhold his assent to the bill, or he can return the bill for reconsideration of the house or state legislature. So when a bill is written, and in that case the house or houses, they have to reconsider it within a period of 6 months, and the bill, it is presented again to the presidential assent after it is passed by the house with or without amendments. And remember that the Constitution does not mention whether it is obligatory on the part of the President to give his assent to such a bill or not. Money bills. Money bills, it can be introduced only in the Legislative Assembly, and the Legislative Council, it has restricted powers with regard to the money bill. After a money bill, it is passed by the Legislative Assembly, it is transmitted to Legislative Council for its consideration. We already learned that the Legislative Council, it has restricted powers regarding the money bill, so that the Legislative Council, it cannot reject or amend a money bill. It can only make recommendations and must return the bill to Legislative Assembly within 14 days. And the Legislative Assembly, it can either accept or reject the recommendations given by the Legislative Council. If the Legislative Assembly accepts any recommendation, the bill is then deemed to have been passed by both the houses in the modified form. And suppose if the Legislative Assembly does not accept any recommendation, then the bill is said to have been passed by both the houses in the form originally that is passed by the Legislative Assembly without any change. If the Legislative Council does not return the bill to the Legislative Assembly, that is within 14 days, in that case, the bill is deemed to have been passed by both the houses at the expiry of the said period in the form of originally passed by the Legislative Assembly. And hence it is said that the Legislative Assembly has more powers than Legislative Council with regard to money bill. And finally, when a money bill, it is presented to the governor, he may either give his assent, withhold his assent, or reserve the bill for presidential assent. But he cannot return the bill for reconsideration of the state legislature only in the case of money bill. Privileges of the state legislature. Privileges of the state legislature, they are the sum of special rights, immunities and exemptions that are enjoyed by the House of State Legislature, their committees and their members. And these privileges are necessary in order to secure the independence and effectiveness of their actions. Note that the privileges of the state legislature, it does not extend to the governor, who is also an integral part of state legislature. The privileges of the state legislature, it can be classified into two broad categories. They are collective privileges and individual privileges. In the collective privileges, it belongs to each house of the state legislature collectively. And some of the collective privileges are, it has the right to publish its reports, debates and proceedings, and also the right to prohibit others from publishing the same. State legislatures, it can exclude strangers from its proceedings, and it can hold a secret sittings to discuss some important matters, and it can make rules to regulate its own procedure and the conduct of its business and to adjudicate upon such matters. So the state legislature, it can also punish the members as well as outsiders for the breach of its privileges or its contempt by reprimand, admonition or imprisonment. No person can be arrested and no legal process can be served within the presence of the house without the permission of the presiding officer. And these are some of the collective privileges. Let's discuss about individual privileges. The privileges belonging to the members individually are, they cannot be arrested during the session of the state legislature and 40 days before the beginning and 40 days after the end of the session. This privilege is available only in civil cases, but not in criminal cases or preventive detention cases. A member have a freedom of speech in the state legislature, and a member are exempted from jury service. That is, they can refuse to give evidence and they can appear as a witness in the case which is pending in a court when the state legislature is in session. This is an individual privileges. See you in the next session with some other interesting topic. Thank you.